Yes.
My Lord, just two matters of housekeeping or
Yes.
document keeping. My Lord Holgate asked, we had a brief exchange about the procedure rules.
Yes.
My friend Mr. Irving Casey has kindly provided them through his junior. I must apologise, it was not the procedure rules that I was thinking of in my exchange with Lord Holgate regarding the detail of what statements of common ground are required to do, expected to do. That's in the procedure guide, the Inspectorate's procedure guide, which I have sent by a separate email, and it's Annex R. Hard copies are Annex R at electronic pages 105 to 106. I'm afraid the rainforest is taking a hit because full copies of the procedure guide are being printed now and will be at court shortly. But that's what the requirements that Lord Holgate and I were discussing,
right,
about identifying the issues and what's in dispute and so on and so forth. They're
yes.
in the procedure guide. So that's what's coming.
Thank you. Yes, Mr. Kelly.
My Lords, the short but important point raised in this appeal is whether the Inspector's report, read as a whole and with the Secretary of State's decision letter, provides adequate reasons for the proposal's compliance with policy 4 of the Waste Plan, and in particular for the proposal's support for the spatial strategy and adherence to the proximity principles. Materially, as you will have realised, there's been no appeal by the Waste Planning Authority for where the proposal is proposed to be placed. And you will also note, somewhat surprisingly, given my learned friend's submissions about what a major issue all of this was before the Inspector, that the closing arguments for the Rule 6 party were completely silent on the issue of the spatial strategy and proximity principles. So I do ask that your lordships treat with a pinch of salt this notion that it was a trump card, that they were playing hard, that it was really central to their case, because if it was any of those things, it would have appeared in their closing submissions, and it simply does not. At root, the key allegation which threatens the delivery of this major piece of UK infrastructure is that despite a detailed inspector's report and Secretary of State's decision, there has been inadequate consideration of where the proposed facility should go. It's my Lord Justice Nugee's point. That's a surprising allegation, given that the Inspector's report and Secretary of State was focused precisely on that issue. As set out in our skeleton argument, we say that the reasons provided were more than ample, and that the position is properly illuminated when the context in which those reasons are given is properly understood. In any event, it's difficult to see how the standard of reasons provided has substantially prejudiced the appellant. In assessing the adequacy of reasons, it's important for the court to have well in mind the way that Dorset Council's case on the proposal's compliance with Policy 4 was put to the inspector, given that the Rule 6 party specifically aligned themselves with Dorset on Dorset's evidence, and I say with the issue. The key to unlocking the case in my submission is understanding the legitimacy of that criticism, the appellant's criticism, the key to unlocking the legitimacy of that criticism is understanding how the parties put their arguments on Policy 4 to the inspector. So my submissions to this court will be developed by considering 4 questions. Firstly, what does the spatial strategy and proximity principle in the Waste Plan seek to achieve? Secondly, how was the issue of compliance with Policy 4 put by the parties to the inspector? Thirdly, what were the inspector's reasons for finding compliance with Policy 4? And finally, were those reasons adequate in the sense that the interests of the appellant have been substantially prejudiced by any deficiency of reasons given? So addressing your lordships on the first issue, what do the spatial strategy and proximity principles seek to achieve? Well, the appellant's case before the judge below was that the Secretary of State had misinterpreted the spatial strategy. In fact, in their supplementary argument to this court, the appellant seems to continue with that argument, saying that it is primarily a locational strategy. Mrs. Justice Lang quite clearly determined it was not, and I refer you to paragraph 82 of her judgment. For your notes, that's at Core Bundle 116. I don't ask you to turn it up, but just to note it. I also say that the appellant doesn't have permission to appeal on the basis that Mrs. Justice Lang got the interpretation of the strategy wrong, or that the inspector misinterpreted the strategy. Indeed, the order of Lord Justice Lewison granting permission on the single ground, which can be found at 535 of the Core Bundle, makes clear that, so far as he's concerned, there's no allegation of any misinterpretation of policy. This appeal is solely about the adequacy of reasons. The spatial strategy is the strategy underpinning the entire waste plan. And for your note, Mrs. Justice Lang summarises this admirably at paragraph 82 of her judgment, that's Core Bundle 116. The spatial strategy is concerned with providing sustainable waste management facilities to address the need for an identified shortfall in capacity on sites which provide benefits in the context of the overall waste plan. That is what the spatial strategy seeks to do. And that description is a fair summary of the supporting text to which you've already been taken. That, for your note again, is paragraph 5.1 to 5.4 of the spatial strategy on page 30. It's the detail of the spatial strategy which is then set out at supplementary bundle page 31, and I will just ask you to turn that up, please. So the detail of the strategy, I say, is set out on those 2 pages, 31 and 32. The opening sentence of the policy sets out the purpose of the spatial strategy and makes clear that the strategy is about meeting the needs set out therein. In fact, Mrs. Justice Lang again noted below that the overall purpose of the spatial strategy is reflected in that first sentence of the policy text. And the reference for your note is her judgment at paragraph 88, Core Bundle 117. The needs referenced in the second sentence are needs for strategic recycling facilities, local recycling facilities, green waste composting, food waste composting, and the others that are then set out below. The identified need relevant to this appeal, as your lordships will no doubt have gathered, is on page 32 under the subheading Residual Waste Management. I ask the court to read that section.
Yes.
So the spatial strategy acknowledges that there is a capacity gap for residual waste and that appropriate facilities are needed to manage the waste whilst ensuring value is obtained through the recovery of energy where possible. The text relating to residual waste management explicitly recognises that the need for residual waste facilities will primarily be addressed through new capacity in South East Dorset, but that additional capacity may also be appropriate elsewhere to ensure the capacity gap is addressed, and when it will result in a good spatial distribution of facilities, providing benefits such as a reduction in waste miles.
What does good spatial distribution now mean?
Well, my lord, in this instance, I say, in the context where there are no such facilities, having a facility is a great thing initially. But of course, if one has more than one facility, then one might look to the locational aspects of the spatial strategy when considering that part of it.
If we read on to the end of that sentence, providing benefits such as a reduction in waste miles, it might have the proximity principle in mind.
My lord, yes. Reference is, of course, then made to the 4 existing waste management sites which have been allocated under the plan to address the need, and those are at page 37 of the supplementary bundle. And you'll see the 4 sites set out at the top of 37 in the various insets 7 to 10. But you will note that in the text at paragraph 6.9, which is below that box, the plan specifically envisages that it's a possibility that these allocated sites may not come forward as expected. It recognises realistically that it will be commercial considerations that will determine whether these facilities will actually be built. Now, it is common ground, no doubt Mr. Burton will jump up if I'm wrong, that these sites have been allocated since 2006. And none have come
That
forward.
does need to be caveated, actually. But
You're referring to an earlier local plan.
I am, my
And
lord.
that is referenced somewhere. It's in the inspector's report. If we can be given the reference at some point.
My lord, I'll ask my junior to look that up. But yes, I shall give you that reference. But
Because I think we read that the allocations have been rolled forward.
they had from a previous plan. My understanding was that they had been in there since 2006. But no doubt Mr. Burton can caveat that in reply. But I will ensure that that reference is given. So as
Is
for
this-
sorry,
Is this standard that waste authorities don't themselves build facilities, they rely on the private sector to build them?
my lord, yes, yes. As foreshadowed by
I mean, there might be some exceptions. I think there was one in Coventry, which I dealt with in the House of Lords, but generally speaking, it is private investment, isn't it? Particularly nowadays, I should think.
yes,
So all the waste authority could do is say this is a good place for it. It can't actually secure that anything is built.
my lord,
on that
correct.
site.
Yes.
But do they perhaps have an input in as much as they presumably still enter into waste contracts?
Yes, they do.
And it's on the back of the waste contracts that it might be worthwhile someone investing, if there's a sufficient income stream looking into the future, investing in the capital plant.
My lord, yes.
Okay.
Yes.
So, I mean, as my lord asked, the local plan isn't sort of an academic exercise. It presumably is meant to have regard to the practicalities and the realities of bringing about a site. Having said that, your point is that this is a case where the facilities haven't come forward for a long time.
Precisely.
Meanwhile, the waste is going where it's going.
Precisely, out of county and indeed out of country. And then paragraph 6.11 over the page explains how policy 4 will treat applications for facilities on non-allocated sites. And I'll just ask your lordships to read that.
Yes.
Now, you've heard much mention, my lords, of this issue of need and the unmet need, but I want to drill down to show you what the waste plan says about that, and that's further important context to the spatial strategy. It's important to understand the extent of the identified need and the existing capacity in the waste plan area, and that's dealt with at page 58 of the supplementary bundle, and I invite you to read paragraph 7.60 to 7.64.
Yes.
So it's specifically noted therein that there's only one facility in the plan area which treats non-hazardous residual waste, and that residual waste is currently being exported to other counties. Now, my lords, within the inspector's report, you will have seen reference to table 7 as being the table which sets out the need. And table 7 in the waste plan deals with the shortfalls and required capacity in the plan area. And that
sorry to
yes.
interrupt, just to get the picture.
Yes.
That's dealing with recovery, etc.
Yes.
But in terms of what happens to residual waste, there's also further discussion over the page, including landfill.
Yes.
769 and including Bridgewater in Somerset.
Yes.
770.
Yeah, so there are waste contracts, as I understand it, with Bridgewater and Somerset, and there are landfill sites, but nothing that pushes the.
So even when it goes out of county, is it going to an EFW or treatment, or is it just landfill?
I can't assist with that. I'm afraid.
What we've got
So
is
from what we've
this.
got is this, yeah.
Sorry.
Table 7 is the table that I'd like to take you to. That's explained at 7.71, and this is where we get the figures on need. So I just invite you to read 7.71 and 7.72, and then you'll see the table itself on page 59. On page 60, sorry.
Yes.
So there was an agreed upward adjustment to the identified shortfall figure between the Waste Planning Authority and PPL, such that it should be increased. So the identified shortfall should be increased by 95,000 tonnes per annum. So for 2028, for example, subject to the parties' wider dispute about total need, it was agreed between the Planning Authority and PPL that the shortfall figure for 2028 would be 309,000 tonnes, rather than the 214 which is set out on that table. And that's against a projected need figure of 339,000 tonnes. So in 2028 there would be a need for disposal of 339,000 and a shortfall of 309,000 tonnes. And just for your note, if it's contentious, I don't think it is, Dorset Council accepted the upward adjustment of the shortfall. That can be found in the inspector's report at 6.107, which is core bundle 398. So Dorset Council's case before the inspector on need was that there would be a need figure of 155,600 by 2025, 109,400 by 2050. That's what their case was. That case was roundly rejected, and the table, subject to the upward adjustment that I've just taken you through, was the evidence that the inspector found applicable. And at 7.74, the implications of the identified needs are outlined. Given the scale of the shortfall, the plan anticipates provision of additional recovery capacity in the waste plan area to ensure that the plan area can aim for net self-sufficiency. And at 7.76, I'll invite you to read that. The allocation of specific sites are explained.
Yes.
So the thinking was, at the time the plan was adopted, that if all these sites came forward, they would cumulatively meet the identified shortfall. And as I say, despite those sites having been in the current and previous plan, none of them have come forward. Over the page, I ask you to read 7.78. which identifies the consequences for the spatial strategy and proximity principle if new facilities cannot be brought forward in the plan area.
Sorry,
7.78 over the page at 61.
Yes, thank you.
So it's abundantly clear in my submission that new facilities within the waste plan area are preferable to sending waste outside of the plan area, and that would conform with the spatial strategy and proximity principle. So bringing all of those strands together, we must answer the question about what the spatial strategy seeks to achieve in respect of residual waste management facilities. Well, it seeks to achieve the 7 objectives identified by the judge at paragraph 90 of her judgment. That's the paragraph that my Lord Justice Holgate took my learned friend to. It's at Core Bundle 118. I don't ask you to turn this up now, but that is what comprises the spatial strategy. The judge hasn't obtained those elements from anywhere other, in my submission, than the supporting text at page 30 in the bundle, which is the spatial strategy, the supporting text at page 30 and the strategy itself at pages 31 to 32. And the reason I say that, my lords, is because that part of the judgment was lifted from my skeleton, and I got those elements from the supporting text and the strategy itself. And that is all by way of introduction, if you like, to say that it's simply not the case, as contended by the appellant, that this spatial strategy is primarily about directing waste facilities in a particular location. It's simply not. It goes far wider than that. So when one looks at whether this inspector has given adequate reasoning on the issue of the spatial strategy, you mustn't only have the issue of location in your mind.
It's fair to say, though, that it does seek primarily to distribute the facilities in
South
East.
Yes, that is fair, my lord, yes. But we know that since 2006, and certainly since this plan has been extant, none of those allocated sites have come forward. And we know that the waste need continues and, on the inspector's finding, remains pretty desperate.
When was this plan adopted?
This is the 2019 plan, my lord.
2019.
The references to 2006 come from the inspector's report at paragraph 8.7. That is the appellant's point that these facilities have been in the predecessor plan since 2006. What the inspector says about it is at 12.11, and he's a bit more circumspect. He just says that the allocations have not been taken up for some time. Those are the words used by the inspector at 12.11. But there is an important point about the text of policy 4 itself. So if we go to that at page 40 of the supplementary bundle, and when one looks at Waste Plan Policy 4, and specifically 4C, when considering whether a proposal for a facility on a non-allocated site will support the spatial strategy, the decision maker is directed by 4C to the question of whether the proposal supports the delivery of the spatial strategy, then hyphen, in particular, contributing to meeting the needs identified in the plan, moving waste up the waste hierarchy and adhering to the proximity principle. So the words after the hyphen show or reinforce that the spatial strategy is indeed multifaceted. And whether or not a proposal meets the residual waste needs of the waste plan area is central to the question of whether it's supporting the spatial strategy. So, in summary, the text of the spatial strategy and its supporting text make clear what it seeks to achieve. If there was any doubt, the text of policy 4C itself makes clear whether the needs of the plan area being met is central to supporting the spatial strategy. As to the proximity principle, that is not a term defined in the waste plan. If one turns to policy 1, I think you've already been taken to it, page 25 of the bundle, that provides that proposals for development of waste management facilities must conform with and demonstrate how they support the delivery of the following key principles, and then proximity facilities adhere to the proximity principle through being appropriately located relative to the source of the waste.
You said it wasn't defined. Doesn't paragraph 316 define it?
Well, my lord, the problem with, I suppose, paragraph 316 is that it's supporting text to the policy, and whilst one can use that as an aid to interpretation, it would be wrong for me to submit that that is a definition in and of itself. But that is certainly a tool which the court can use when it interprets what the proximity principle means.
Well, you often find definitions outside the quotes policy, sometimes in the glossary. And what you can't do is see the Churchley case, if that's how you pronounce it, is
Yes.
use the lowercase text to contradict or add materially to the policy. But if it's just explanatory of, wouldn't that be taken into account as a definition?
My lord, yes, but I wouldn't want the court to think that that was an exhaustive definition of the proximity principle. But that is, I agree, that is something that the court should have regard to, both that supporting text and the box in policy 1. And so what one gets from that in my submission, it's clear what it says, but also that the proximity principle is embedded in itself within the spatial strategy. I refer you back to the words that we were just looking at policy 4C. Adhering to the proximity principle is one of the things, the others being moving waste up that waste hierarchy and meeting need, which supports the delivery of the spatial strategy. So, my lord, that is what I wanted to say by way of the first issue, that is the spatial strategy and the proximity principle and what they seek to achieve. I now want to move to the way in which the issue of compliance was put by the parties to the inspector, because I think that is crucial to understanding whether adequate reasons were given. So the issues between the parties at the inquiry were set out by the inspector in the usual way, and one can see what those issues were. It's Core Bundle 477 and paragraph 12.2 of the inspector's decision. My lords, I'll just ask you to read that to yourselves.
Yes.
So the appellant, as far as we know, didn't take issue with the way those had been formulated, and they would no doubt have been canvassed with the parties in the usual way. Therefore, the focus of this court when determining the adequacy of the Secretary of State's reasons should be on the parties' closing submissions on the first issue, and on how the planning balance should be struck. that is where we find the way the parties dealt with the proposal's compliance or otherwise with Waste Plan Policy 4. We know that the inspector's approach to the most important planning issues is highly relevant to the evaluation of the reasons that he provided on them, and the reference and authority for that is the Authorities Bundle 142. The case of St Modwen. Yes, it's the case of St Modwen and the Secretary of State Communities and Local Government, which is 2018 PTSR 746, and specifically the judgment of Lord Justice Lindblom at paragraph 6.6. So I'll just ask you, my lords, to read that. In fact, it might be useful to read the whole of that page. So from subparagraph 1 right through to the following page.
Yes, thank you.
So back to the decision letter and back to the way that the waste issue was developed by the inspector. So the waste issue is further explained by the inspector at paragraphs 12.3 to 12.5, and I'll just ask you to read that to yourselves.
By waste issue, that's a term of art which is defined in issue A in 12.2.
My lord, yes.
Yes.
So those paragraphs are crucial to understanding how the battle lines were drawn between the parties on the policies within the waste plan. The entire context, you will see, of the Waste Planning Authority's arguments concerning the Waste Plan 2019 is set out by the inspector at 12.5. And as recognised by Mrs. Justice Lang below, the council relied on a new position regarding waste at the inquiry, namely that the need issue, and that was not an issue that had previously been canvassed and was not a separate issue from RFR 1, but one which led to whether the spatial strategy had been complied with or not. So you will see at 12.5, to a large extent, the council's case on the waste issue rests on this point and the suggestion that the need for residual waste management capacity is now significantly lower than the need the Waste Plan 2019 was predicated upon. So this is really important because what the inspector is doing is accurately identifying how the case on the waste plan was put to him by the Waste Planning Authority, and recognising that to a large extent, that entire waste issue that my Lord Justice Holgate has termed a term of art and has been foreshadowed above, the answer to that issue from the council's perspective rests on their case on need. That is what the inspector is telling us. So that summary of the argument at 12.5 is wholly consistent with, I say, Dorset Council's closing submissions to the inquiry, which recorded that same approach in their submissions on the planning balance. And of course, that is where you would expect to find the party submissions on whether or not there has been policy compliance. The inspector accurately records what that submission was. If we turn to page 406 in the core bundle, so turn back to 406, it's paragraph 6.137. This is where the link between waste need and the spatial strategy is drawn out by the Waste Planning Authority. And I ask you to read 1.37 to yourselves.
6.137.
6.137 on page 406. Thank you.
Yes.
So the case is put squarely in terms of the evidence on waste need. So the Waste Planning Authority is saying, in light of the evidence on waste need, it would not support the delivery of the spatial strategy, and in particular contributing to meeting the needs identified in the waste plan. And then you will see in the final sentence, as such, there would be conflict with policy 1, 4C, and 6A and B of the waste plan 2019. So that is a very specific way in which the case on 4C was put. Dorset was saying 4C is not complied with in light of the evidence on waste need.
But in effect, they were saying there'd be overcapacity if the need figures are lower, and the adverse consequences of that would be to reduce recycling rates, for example.
Yes. Yes, but the point I'm making, my lord, is that the case on 4C, of course, didn't incorporate issues such as location and so on. It was narrowly focused on the issue of need. That is the way it was put in closings. And of course, what my learned friend says is that, well, it goes wider than that, and it's about location and other aspects of the spatial strategy. But here we have, in the closing submissions, tying the case on waste need with compliance or otherwise with policy 4C.
What's 6.139 addressing?
Well, it's the same point. So it's saying that, to be clear, even if the case on need is accepted, meaning that there would be compliance with policies 1, 4 and 6, so that's the opposite of their submissions.
I understand that, but then the next sentence is that indeed the 3 reasons for refusal stand on their own terms, individually justified. So that seems to be saying that they would still be relying on the 3 reasons.
Including the totality of the first one.
Exactly.
Well, that would be, it would appear inconsistent, would it not, then, to say that they concede policy compliance with
But
policy
it
4?
depends whether that's the right reading of what was said in their closing submissions. Can I see if I've understood what's being said here?
Yes.
You seem to be suggesting that the council accepted that if they were wrong quantitatively on the need case, then ipso facto there'd be compliance with policies 1, 4 and 6.
That appears to be what they're suggesting, my lord, yes.
query, is that how it's to be read? Because if one meant that, you wouldn't need to make any comparison with other sites.
Well,
I mean,
my lord,
you
yes.
wouldn't need to talk about the proximity principle or any of these other issues.
Correct.
So that, to me, that doesn't make
yes.
a great deal of sense.
Yes, but it shows the focus, does it not, on this issue of need with compliance with Policy 4 and the way the battle lines were drawn and what the inspector considered.
I, in my own simple mind, I can understand why, if there was this big battle on need quantitatively, you would treat that as a precursor before you, because if they were right on that, you wouldn't need to bother about all the others.
Exactly.
But the contrary position doesn't follow. If there was, I mean, in terms of the waste strategies, you've shown us very carefully, if there is a defined need, a la Table 7, then there are various ways of going about meeting that need, including the allocated sites. And if they're, for one reason or other, they're not available, then you can look at other alternatives. But all of that involves looking at, amongst other things, the proximity principle.
It does, my lord. But what I'm trying to do is just illustrate the extent to which the case of the local planning authority, the Waste Planning Authority, was reliant on need. That was the major part of their case. And everything else, when you look at the submissions on the proximity principle, for example, my lord, which I'm sure you have, their closing submissions on the proximity principle incorporate lots of submissions about need and tie the submissions back to need, do they not? We can go to it, we will go to it in due course, but you will see woven through the way that the proximity principle and the spatial strategy closing submissions are made by the Waste Planning Authority are these submissions on need. They are intimately connected. The appellant, for their part, my lord, their closing submissions to the inquiry wholly align their position with the council's evidence for why the proposal should not comply with policies 1, 4 and 6. And the reference to that in the inspector's decision is 7.62. That's at page 426 of the core bundle. And for your note, the actual closing, the part of the actual closing submissions relevant is in the supplementary bundle at 363. So when assessing the appellant's criticism of the reasoning on policy 4 compliance, including policy 4C compliance, it's crucial to bear in mind the way that the arguments were put. So when one steps back and looks at the individual submissions on the spatial strategy and proximity principle, again, in my submission, it's apparent that the case on W4, on planning policy 4C, was inextricably connected to the case on need.
Yeah, I'm sorry.
Yes.
Could we actually look at the council's closing submissions?
Yes.
Because what the inspector has summarised seems to come from supplemental bundle, page 328, paragraph 128. And maybe I've misunderstood what you're saying, but I understood that when you refer to need, you're talking about quantitative need. Looking at what is the need to deal with the risings in the plan area. But there it is, to be clear, even were you to accept the appellant's case on need, i.e. assuming there would be compliance with etc., etc., etc. But they get to this position before they turn to benefits. If you turn back a couple of pages,
Yes.
having looked at, see paragraph 124, waste miles.
Yes.
So when they're talking about needs relative to the policy, they seem to be building in other factors like proximity and not just looking at the quantitative exercise, the shortfall, which would make more sense to me.
My lord, if you look at what paragraph 1, 2, 3 immediately above,
Yeah.
you'll see that so much of the argument is predicated on their case on need. So the middle of that paragraph, waste from outside the plan area, which the plant will increasingly be reliant upon as the plan area arisings fall. So that is a direct reference back to their case on need.
Yes, I follow that. But there is a connection between the quantitative exercise and these other planning considerations as well, such as proximity and recycling. They're not divorced.
Yes.
So that, hey presto, if the council wins, sorry, the developer wins the quantitative need argument, you don't have to worry about policy 4.
My lord, no, I
I'm
would
struggling
accept
to understand, but
that. I would
and
accept
I
that.
don't think the inspector could possibly have meant that, because if he thought that was the right approach, he wouldn't have gone on to deal with all the other policy
Yes.
issues.
No, I accept that, my lord.
Would have been a shorter decision.
Yes.
And maybe a different sort of challenge.
Yes. Yes.
That's. I mean, are you going to say anything about the statement of common ground? Because there we see the issues being defined up front.
My lord, yes. I haven't quite understood the criticism relating to the statement of common ground, because of course how the case is put in the statement of common ground is how the inspector deals with it. So when one looks at the dispute on policy 4C, what one sees in the column to the right is a dispute, of course, about comparative sites, which is what the inspector does. The inspector compares the sites and addresses the very nub of the issue that is identified in the statement of common ground.
And perhaps read that way, and speaking for myself, I may need to read the closing submissions again, but that would be consistent with those submissions read as a whole, not
Yes.
just paragraph 128.
Yes, yes. So, my lord, then moving to the third issue of identifying what the reasons were for finding compliance with policy 4, it's vital in my submission to understand the inspector's reasoning on the waste issue. That was the issue where the submissions on compliance with policy 4 were advanced by the parties. The key finding by the planning inspector was that the waste plan 2019 figures on need were up to date, and he agreed with the submission of PPL in that regard.
As amended.
As amended,
Yeah,
as adjusted.
95,000.
My lord, yes. And the reference for that is his decision at 12.9, page 478 in the bundle. And given the centrality of the need submission, the planning inspector correctly reported to the Secretary of State that that was a finding of his that was fundamental to the determination of the appeal. That's what he says at 12.10 of his decision. At 12.11, the planning inspector records that the Waste Plan 2019 identifies allocated sites, but reflective of the fact that those allocations have not been taken up, despite having been around for some time. The plan also includes provision for waste management facilities to come forward on sites that are not allocated. The inspector notes that that is an unusual approach, and policy 4 is permissive of waste proposals on non-allocated sites, where, among other things, the non-allocated sites provide advantages over the allocated sites, and the reference of my submission to among other things makes clear that this was an inspector who was aware that policy 4 had those additional requirements, other than a comparison between sites. When he's considering other matters, or the subheading other matters at Core Bundle 488, he considers carbon emissions and the potential climate impacts of the proposal. And within that context, his reasoning on the proposal's compliance with the proximity principle is made clear. It must be remembered this is not an inspector who's writing an examination paper on every material consideration that has to be referenced in every paragraph. That was paraphrased from the judgment of Lord Justice Hoffman in South Somerset against David Wilson Holmes, 1993, 66 Property and Compensation Reports 83, and for your note, that's at tab 7 of the authorities bundle at page 85. So the fact that the reasoning relevant to the proximity principle is under the heading of other matters and relating to carbon emissions and climate impacts is irrelevant in my submission. Reading the decision letter as a whole, this is a planning inspector who's provided adequate reasoning in respect of the proposal's adherence to the proximity principle. It must be remembered also, my lords, that minimising impacts on environmental assets and amenity also forms part of the wider spatial strategy. So on that basis, the matters that are considered under climate impacts are also relevant to the proposal's compliance with the spatial strategy. And what the planning inspector makes clear at 1295 is that burning residual waste in this location would result in lower carbon emissions than the present situation where the planning authority disposes of its residual waste partly through landfill and partly through incineration outside of the plan area with consequent waste miles. The reference to waste mile savings is the key matter central to the council's evidence on the proximity principle. You'll see how the council gave that evidence within Ms. Hart's proof. It's at supplementary bundle 263, paragraph 238. And I just ask you to read that paragraph to yourself.
Well, I just note in passing 43792, 437 to 4318.
Sorry, my lord, I'm not with you.
Well, I'm looking. You're asking us to look at 238.
Yes, 263, paragraph 238.
Yeah. The second line refers to 4318. Mr. Roberts, was that part of the section we looked at this morning? Perhaps if someone could tie that up. I thought there was emphasis on 4318, but I may be wrong. This is what she's responding to.
Yes. So the evidence, Mr. Roberts, I think starts at 147, 4318, is it 169? Sorry, 179.
Yeah, it was 4318, page 171. So
You were taking this,
she's responding directly to that. Okay.
Yes.
Yes.
And the submission there is that there is an emphasis on waste miles travelled, and so it's unsurprising when the inspector then comes to consider the proximity principle that that is the way in which he expresses himself. Also, the evidence, Mr. Potter, SB1, supplementary bundle 131. Paragraph 3.31. And the submission is then the same. Again, waste miles is what the focus is. Waste miles is how the inspector expresses himself in his decision. So moving to the overall balance and conclusion section of the inspector's report, the planning inspector does not specifically separate out his reasoning on policy 4A and 4C, but that is unsurprising, as I think my Lord Justice Holgate has picked up upon, because the submissions of the parties, of course, didn't separate out matters in that way. In fact, the appellant didn't make any submissions on the spatial strategy or proximity principle at all. So when considering the question of whether there are adequate reasons provided for the proposal support for the spatial strategy, it must be remembered that the waste plan tells us that support for the spatial strategy is about providing sustainable waste management facilities to meet the identified needs whilst minimising impact on environmental assets and amenity. Crucially, the planning inspector provided reasons for why the proposal would address the capacity shortfall, thereby meeting the need for residual waste management. And that is the most significant way in which the proposal would meet the spatial strategy. We know the planning inspector did provide reasons as to the proposal's compliance with the locational aspect of the spatial strategy. It was obvious to the inspector that Portland is not in South East Dorset. That did not need to be spelt out. But the inspector specifically found that the site at Canford Magna would perform better in terms of the locational aspect of the spatial strategy. He says precisely that at 12.108. The comparative approach to location is how the council put their case on the proximity principle. And the reference for that is Hart's proof at paragraph 8.42 at supplementary bundle 217.
Well, 842 is where it starts.
Yes, and
Which is the comparative point.
848. Sorry, my lord.
But it's comparison with the allocated sites, assuming they come forward.
Yes. So we know that the planning inspector provided reasons for whether the proposal would support the spatial strategy in other ways. It has an ability to accommodate carbon capture, incinerator bottom ash by sea. Those are matters to which the inspector refers at 12.108 and 12.95. And the inspector determines that this would offset the locational disadvantages relative to Canford Magna. We also know that this is an inspector who considers that the proposal would better promote the spatial strategy than the allocated sites, because it's not in the green belt. My lords, you will note at supplementary bundle page 100, you've got policy 21 of the waste plan. The allocated sites of Canford Magna and Parley are both in the green belt, and they would have to meet those tests. And the inspector notes that those sites are in the green belt, and considers that this current proposal would better promote the spatial strategy than the allocated sites which are in the green belt. And again, I remind you that protection of environmental assets and adherence to Policy 21 are matters relevant to support for the spatial strategy. So then, my lords, turning to the final issue, were these reasons adequate and has the appellant been substantially prejudiced? Well, in my submission, the reasons were adequate. What more, I ask, could the Secretary of State or the Inspector have done other than add a line specifically to say that this is a proposal that complies with the spatial strategy and adheres to the proximity principle for the purposes of Policy 4C? But of course, he doesn't have to do that because he's found compliance with Policy 4. That is what we take from paragraph 12.109. Having earlier spelled out that he was aware that the spatial strategy was a multi-limbed policy. The court is very familiar with the law and the applicable legal test on adequacy of reasons. We looked at it, Lord Brown from South Bucks, District Council Reporter number 2, 2004, 1 Weekly Law Reports, 1953 and 1964, paragraphs 35 and 36, and I merely cite that for your note. So, in summary, we say that the inspector's report and the Secretary of State's reasons on Policy 4 are adequate because they make clear, firstly, that there is significant unmet local need for residual waste management. Secondly, that the appeal proposal will help to meet that unmet need, and in that way, it will support the delivery of the spatial strategy. Thirdly, the appeal site had significant advantages over the allocated sites, even though the locational aspect of the spatial strategy would be better supported at Canford. And finally, that the proposal would adhere to the proximity principle because it would be a clear improvement on the status quo and would reduce waste miles. I think my learned friend Mr. Elvin has submissions on the no substantial prejudice point, and we would adopt those, but those are the submissions that I have unless I can assist your lordships further.
Thank you very much.
Thank you.
Yes, Mr. Elvin.
Please the court. The error in my submission, which the appellant falls into, is in seeking to compartmentalise the issues in the waste plan so far as residual waste management is concerned. Quite clearly, the principles in Policy 1, including sustainable waste management, the proximity principle and the like, are closely linked with the spatial principles in the spatial strategy, which themselves are linked with policies 3 and 4. And the learned friend, Mr. Burton, falls into the classic error of trying to over-compartmentalise aspects of the plan as well as the decision. And the route by which the inspector reached his conclusion, consistent with the parties, main parties in the State Common Ground, was this. There was firstly a need case which was made out. Secondly, it was undisputed, and indeed, as I'll show you in a moment, the waste plan itself acknowledges no residual waste management facilities driving waste up the hierarchy for what's called final fate disposal, i.e. final treatment, existed in Dorset or the other waste plan area in Bournemouth, Christchurch and Poole, and it was either sent out of county or indeed it was sent out of the UK. That being said, the principle of proximity is tied to the most appropriate facilities closest to the waste arisings. Policy 3 and 4 did not assume that the allocated sites were necessarily compliant because they subjected the sites to the other policies in the development plan, that's policy 3A, which included, as learned friend Mr. Coley's just pointed out, policy 21 for green belt sites. And policy 21 specifically, as is consistent with national policy, said that those sites in the green belt had to demonstrate very special circumstances which they would not be able to do if there was an alternative non-green belt site. And it is clear, as you have seen from the inspector's report, and if you want to look at the plan provisions, I'll give you the page references, the two what are called the insets, which set out the Canford and the Parley sites, which are in the supplemental bundle at pages 172 through to 112, which is the end of the local plan. It sets out the two site allocations. Both are said to be in the green belt. And if I could ask you to turn up, for example...
Sorry, can you give those pages again?
Yeah, of course, my lord. It starts at page 107 of the supplementary bundle. I'm afraid they're the landscape pages because that's
right.
where they're here in the plan. You have Parley first.
Yes.
And if the court would please look on page 108.8, the point is made expressly, given the site's location within the southeast Dorset Greenbelt, applications will be considered against national policy and waste plan policy 21, etc. You see an almost identical paragraph for Canford at paragraph 5 on page SB 111. And as the inspector appeared to infer at paragraph 1211 of his report, which Mr Coley referred to, it may be that the policy allocations which were rolled forward from the previous plan didn't completely satisfy green belt requirements, which is why the plan, unusually as the inspector remarked, included the unallocated sites policy 4. In other words, if the allocated sites failed against other development plan policy, in this case the green belt, then that was something which had to be considered in the light of the non-allocated sites policy. Because, of course, applying the criterion in policy 21 that they had to show that they could not be met by alternative suitable non-green belt sites. That's SB page 100. Criterion B in policy 21, then of course those sites couldn't come forward. And it's irrelevant to the challenge, but in fact Canford was ultimately refused because it was a green belt site. Refused in June. Those policies are tied together, and as I've submitted, what is proximate depends on what is available and what is most appropriate. If I could ask the court to look back at the way proximity is dealt with earlier in the plan, which I think, a point my Lord Justice Nugee was making, can I ask the court to go to SB page 24, please?
Yes.
If the court goes to 316 at the bottom of the page,
Yes.
the principle of proximity, etc., the waste infrastructure network must enable waste to be managed in one of the nearest appropriate facilities. So it stresses the appropriateness of the facilities, which must mean spatially appropriate and appropriate in terms of the other policies, in my respectful submission. And if I can then ask the court to go forward to section 7, which is dealing with residual waste amongst all the other categories of waste, at SB page 58, under the heading Existing Capacity and Recovery. And this was a recovery plant because it was recovering the waste in the technical waste directive sense of converting it into energy and heat. Page 58. Could I draw the court's attention to paragraph 762 to 764, which acknowledges that there are no residual final treatment facilities within Dorset or the BCP area. The only facility they have is the MBT plant at Canford, which is simply processing the waste but not achieving final disposal. It then goes on from there to another site. And in fact, the Canford waste through the MBT plant was then being sent to Bridgewater under a contract which ran to 2027. That's it in the material I'll show you in a moment. The Canford facility that existed wasn't actually a residual waste facility, it was merely an intermediate treatment facility. So the plan itself acknowledges there is no residual facility. That was also the subject of evidence, as the court has seen. My Lord Justice Holgate's already drawn attention to 6.3.17 and 6.3.18 in Mr. Roberts' evidence. Can I also draw your attention to paragraph 4.2?
Was that 6 or was it 4?
Oh, sorry, 4.3.17, 4.3.18. I do apologise. I also asked the court to look at 4.2.5 in his proof at SB 155. He makes the short point that the allocated sites, and he's referring to Parley, Canford Magna and Binnigar, one of the other 4 sites, have not delivered since inclusion in the plan adopted in 2019, although the draft allocation was identified at least 2 years prior to that. 90% of Canford was in the earlier waste plan. They failed to deliver.
Vinegar is another allocation altogether.
It is. You haven't got
one of the 4, but
it's
not one of the 2.
No, as Mrs. Justice Lang held, it was by common consent at the inquiry that only the 2 were focused on in evidence. Vinegar, in fact, the inset, although you haven't got it before you, says it shouldn't be a site for incineration, so it's not couldn't be an energy recovery site. In any event, the position, therefore, was this. No waste was being properly treated within Dorset, Bournemouth, Christchurch or Poole, the waste plan area. It was being sent either out of county or, as Mr. Roberts pointed out of the country. Some was going to Hampshire, some was going to Somerset, some was going, I think, to Germany, I can't remember. So it self-evidently, if the other sites were not appropriate in terms of that lowercase text definition, then a non-greenbelt site, which was at least in the middle of the county, even if it wasn't close to Bournemouth, which was the preferred spatial location, was obviously better placed to perform in terms of proximity, self-sufficiency and the like, compared with the current situation. And there clearly was a dispute between ourselves and Dorset as to how you calculated waste miles. One of the key points which you'll not see addressed in either Mr. Potter nor Miss Hart's evidence is they do not do the comparative exercise which Policy 4 requires as between the allocations and the proposal. They simply adopt a position that they prefer the allocations. And indeed, as we pointed out in closing, they did not address the question of the acceptability of the Canford site, for example, in greenbelt terms. And that's referenced in the closing speech on the first page. So, that being the case, if proximity is to be met in an appropriate way, on an appropriate location within the plan area, the question of whether it should be met on an allocated site or a non-allocated site was obviously of critical importance, which why, coming back to my Lord Justice Holgate's question, the way the issue is put in the statement of common ground is important, because contrary to what Mr. Burton has submitted, criterion 4A is closely related, because of the facts of the case, to criterion 4C. Because Dorset, Bournemouth, Christchurch and Poole had no existing final fate facilities, and because the 2 main alternatives were greenbelt sites to which the appeal site presented a clear alternative which was outside the greenbelt, the decision whether or not to consider the appeal site as meeting policy 4, including proximity, self-sufficiency and the like, was answered to a large extent by the question as to whether that site was to be preferred to the other allocated sites.
I'm just being a bit slow, but presumably you don't apply the proximity principle in isolation from other relevant waste strategy, which would include pushing waste up the hierarchy.
And self-sufficiency.
Yeah.
Dorset and the waste area were not self-sufficient. We had an argument about a strange concept known as net self-sufficiency.
I gave up on that.
That way madness lies, my lord. The inspector rejected it. We spent a lot of time debating it, but as you'll see from the inspector's report, he didn't accept it. But your lordship is absolutely right with respect. If you look at policy 4C, it isn't just delivering proximity, it's delivering on the principles of the spatial strategy, which go much wider than proximity. And
otherwise, you might make a decision just looking at proximity, but ignoring the fact you're trying to push the weight for. I mean, the landfill might be closer, for example.
Well, indeed, and if one of the points that was again rejected by the inspectors, the council was also saying, well, you're going to affect our recycling rates, so you're actually going to have an adverse effect on the waste hierarchy in some respects.
So these factors are interrelated.
These factors are all interrelated, as is the issue of meeting the spatial strategy and whether the allocated sites are appropriate, applying policy 3A and policy 21. In this context, with respect, can I agree with my Lord Justice Holgate about the way the matter was put in the council's closing submission at 6139? The inspector recorded the council as saying, well, even if we're right, even if we're wrong about the waste policy side, waste capacity and policies 3, 4, etc., there remains, this is the question about what did the council mean in its closing speech. What the council appeared with respect to be saying is, well, even if we're wrong on all the waste issues, capacity and the other issues,
you've still got to deal with landscape and heritage.
And with respect to everyone on this side, the main time that was taken at the inquiry, apart from me, was spent on the World Heritage Site, landscape and heritage,
which is not surprising.
Which is entirely unsurprising, which you see from the amount of space that takes up in the inspector's report. So all the council was saying is, well, if we're wrong on all these issues, there remains landscape and heritage. That's precisely the way the inspector approaches it in section 12, because he starts by saying, I'm going to deal with the waste capacity issue. I resolve that against the council. However, before I go on to look at policy 4, I need to deal with all these other issues because they may create an insuperable obstacle for the appeal proposal. So he's doing exactly what the local authority was suggesting. Look at landscape, heritage and other issues, and only if they are resolved against the objectives do you then go on to look at policy 4.
Because otherwise they could have been knockout blows.
Of course. And what's the point of dealing with them if you don't need to, other than a short paragraph saying I don't need to deal with these but. So the inspector's approach is entirely in keeping with the way the case was presented to him. It's entirely in keeping with the statement of common ground. And I respectfully agree with my own friend Mr. Coley when he says the so-called trump card was never played by the appellants. You got their closing submissions. They were simply content. I know Ms. Tulip put in her evidence, and that of course was there and she was entitled to say it. But when it came to closing, which was done through council, and they played a full part in the inquiry for the entire period of the inquiry, that point was left to the council submissions, as the inspector records in his report, and you've got the actual paragraph itself in the in their submissions in the supplementary bundle to check it against. I don't need to take you to it. But in any event, it makes little difference because the way the matter is structured is clearly consistent with the policies of the plan and the spatial strategy, is internally coherent, and meets with the way the parties argued the cases, and the inspector's approach is entirely clear. If I can just pick up this point about the waste miles, as I've submitted to the court, the council did not consider the comparative status of the allocated sites in any detail at all. And if the court goes to the waste miles summary of the council's submissions, core bundle 405, 405, please. This is consistent with what Ms. Hart said, who also didn't do the comparative exercise. The court, I think, has been referred to 6.134 and 6.135 already.
This is all part of recording the council submissions.
Accurately recording them, yes, indeed. And you've got the actual submissions to compare.
could you give me the reference?
I'm sorry, my lord. CD 405, paragraph 6134, 6135 of the inspector's report, recording the council's submissions on waste miles and proximity. What you see at 135 is the council acknowledging that their assessment was as against the plan's strategy, i.e. the allocated sites. In fact, Mr. Potter used Canford as the main comparator for the waste miles. They specifically rejected a comparison with the current situation, what they called the current spatial reality, the third line from the bottom of 6135. You see that in the middle, they say that has to be the right approach, i.e. not to compare the current situation. It is true that compared to the Bridgewater site, the appeal site offers an advantage in terms of receiving Dorset's waste. And elsewhere in the paper, Bridgewater is double the distance of Portland. The allocated sites allow for this need to be addressed, if appropriate, that's the sting in the tail, in locations that are much better suited for long-term management. So the council's whole approach is predicated on a blinkered approach that the allocated sites will serve. We don't need to consider the details of the allocated sites. And there was a side correspondence with the Canford proposers who put in lengthy representations to the council, which I think we wearied Mrs. Justice Lang with at one point. But the situation you have seen is clearly resolved by the inspector, who found that there would be very serious objections to the proposals in Greenbelt terms. Harley was too small, and Canford, ironically, was too big. The Canford allocation upon which much reliance was placed was for 25,000 additional capacity, not the 250,000 they'd applied for. So when you see the reference in the inspector's report to it being bigger than the allocation, that's what they're referring to. The 25,000 you can see in that INZET 10 that I referred the court to earlier at the end of the waste plan. It actually gives the quantum. So Canford was much bigger in any event, hence the inspector's criticism of it in Greenbelt terms, and his doubt that it could satisfy policy 21. So the inspector's conclusions at the in section 12, having rejected all of the other grounds of opposition, was to say, well, yes, Canford may well be better in terms of its location because it's closer to Bournemouth, but it has insuperable objections in terms of the plan policies. That leaves us with the appeal site, which is not a Greenbelt site, which has the right capacity, and it has a whole series of advantages, including port power, i.e. providing power direct to the cruise ships, and at one stage the Bibby Stockholm, which is nearby, and it reduces carbon emissions consistent with climate change concerns. And you see the inspector setting out what the advantages are. So he ticked the boxes in terms of policy 4, which has to be read as a whole in any event. You don't just dissect it. And the question about compliance with the spatial strategy was answered by the fact that neither of the two relevant comparators under policy 3 were suitable because of their Greenbelt status. And the plan had left that open goal by leaving those Greenbelt issues to be resolved and making it clear that if there were non-greenbelt alternatives through policy 21, they would be preferred. The Learned Friend says, oh, well, you need to look at the, as the Learned Friends to Burton, it says, well, you don't forget the references in bold. I'll just draw your attention to one of those because it refers to our case where we set out all the problems with the existing waste provision. At the end of the first...
These are the references in chapter 12.
These are the references in chapter 12.
So we're looking at,
Can I
is this
ask-
1295?
In fact, I'd like it to take you back to the first section, the final paragraph, 1214. He ends his general consideration of needing capacity by then saying, I'll need to deal with policy 4. He says, I return to this matter below, but I first intend to deal with the other issues. Obviously, if there's a failure to accord with either, then bearing in mind how policy 4 works, the comparison with the allocated site becomes academic in terms of the waste plan. And he gives a series of bold references. The references he gives to his summary of our submissions, 8.3 to 8.72, include 8.4 to 8.6. Can I ask you to turn those up? This is page 432 of the core bundle. Because he's referring comprehensively to our waste submissions, which begin at page 432, within that range of paragraphs. Is the council's position on the treatment of its residual waste sustainable? And you'll see there, 8.4 to 8.5 makes the point about the absence of provisions. And you'll see it, this is reference to Moylan Friends, reference to the merchant facility. We had evidence before the inquiry, it's referenced at 478. Such an arrangement is only subject to contracts expiring in 2027, this is to Bridgewater, and the current the current incumbent of those contracts has expressly stated their preference to take the MBT output to Portland, which it is at liberty to do so, and there's a reference to a letter from a company called Bopar. So we had addressed the concern that, well, why would you take Dorset waste? Well, the answer is, the operators who are having to ship the Canford MBT waste out to Somerset would much rather come to Portland than take it to Bridgewater. It's half the distance. So the inspector well has in mind our opening salvo about the unsustainability of the current position. And if you want to tie that to our actual submissions, it is how we opened our closing submissions, and you will have that at tab 12 of the supplementary bundle, page, it starts at 271, but it's the first few paragraphs on page 273. So our whole case starts with the current position is unsustainable and obviously does not meet the requirements of the spatial strategy. Waste is not being driven up the hierarchy, waste is going to landfill, waste is not being dealt with proximately, it's going outside the county. A county is not self-sufficient. All matters which chime very clearly with the spatial strategy. Hence, the logic that then unfolds, well, if there's need, if the allocated sites are not to be preferred for good reason, then our site, with its advantages, will meet those requirements because it must be better and is better than the current problem. And in doing so, it is meeting the objectives of the spatial strategy, which, whilst it may prefer South East Dorset, doesn't require it to be in South East Dorset. And that, in my submission, makes the decision-making process by the inspector, as adopted by the Secretary of State, perfectly logical and coherent. And there is no failure of reasoning in its in that approach. Well, unless there are any other matters I can deal with on that sort of fundamental approach to the decision, can I just deal with two additional matters? The two sort of overlap. That is substantial prejudice Although the defendant has somewhat overreacted to our submission, saying we said that there's no substantial prejudice. The only point we were making is that the appellant was is a one issue body objecting to the proposals. There's nothing wrong with that. It's done all the time. But it's the objector parts of Lord Bridge in Save and Lord Brown in Order number 2 which are relevant. So is there any real doubt as to the reason for the decision so that the properly informed objector can understand them? In my submission there aren't, and there's no substantial prejudice for that reason.
But to make that submission, you don't need to go further and talk about, as we do in paragraph 81 of the skeleton, and talk about whether a one-issue organisation or a multi-issue.
It was.
It's that which has provoked the supplemental bundle.
And it was intended no more than to place it in context, and it's entirely consistent with what it says. The role is.
So you rest on the submission that there's enough to understand why the decision went the way it did.
Yes.
Yeah.
And
to understand the implications of it for any further decision making.
Yes. And then related to that is my simplex point, and I entirely accept that the court cannot apply any planning judgment. I simply say this: if there is any concern by the court that the inspector didn't hit policy 4C the nail on the head precisely, then the court can infer from the logic of the inspector's decision what the answer must have been. That may well say, well, in that case, there's no deficiency in the reasons. I'm simply saying if you add need to general lack of provision to policies 3 and 4, to the alternatives being unacceptable, that is not that is just joining the logical dots, if I can mix my metaphors. And it can't have made any difference if the inspector had said, and you're better placed than Somerset, or you're not as good as Canford, which in fact he said in locational terms anyway. So it is merely a joining of the logical dots simplex argument I'm making, not a planning judgment argument. It may be that it all shades back into the reasons issue, and perhaps I'm being too cautious in the way that I put it, but it's raised for that particular reason.
Can I be sure I understood what you're saying about the proximity principle?
Of course not.
Is it as simple as this, or is this an oversimplification? At the moment, there's no final residual waste treatment in the plan area.
Yes.
It gets sent to Bridgewater or Germany or wherever.
Yeah.
So having a facility in Portland is better.
Yes.
Now, it's not better than having one in Canford if you can have one in Canford, but there are real doubts whether you can have one in Canford.
Yes.
So it's better to have it in Portland than not at all.
That was the way your
Is
lordship.
it as simple as that?
Yes. That is a very simple way of putting what I've put in a more complicated way in my summary. Lord, unless there's any other matters, those are my
No,
suggestions.
thank you very much. Yes, Mr. Burton.
Yes, thank you, my lord. My learned friend, Mr. Elvin Casey, in his usual elegant way, makes a very attractive argument, but it is an attractive argument that ultimately is to be rejected because it strays impermissibly from what the waste plan actually says, and commonsensical and attractive thereof though it sounds. It is the waste plan that is the starting point, in many respects the end point. The spatial strategy, as I have explained to my lord, says what it says, and what it says is we'll meet residual waste needs primarily in southeast Dorset, and here are our allocations. And if you want something outside those allocations, then you've got to achieve a good spatial distribution of facilities. And it puts, as you know, particular emphasis on the proximity principle. Now, it's a logical fallacy No, it's the wrong starting point to start from, well, what is the status quo? Policy WP4C, it's not about the status quo.
Well, can I ask a question? Say you had a proposal at Canford which was going to be considered. Surely you'd be looking at the planning merits of that, and, for example, the greenbelt issues and whether there are very special circumstances to override that policy. You would look at what's happening to the waste at the moment. The fact that it's going to Somerset. And you would say it's a jolly good thing, it won't go to Somerset.
My lord, yes.
And more than that, to landfill.
Yes, you
So
may.
how can it be any different, I ask,
Hmm.
if you're actually dealing with an alternative proposal on a different site, such as Portland?
Because policy 4 takes things in stages. It asks the question my lord has raised, the issue that my lord has raised, under criteria A. I say it asks it. That's where it falls under criteria A. Advantages, disadvantages, the comparative exercise. That's the second limit of criteria A. Under C, it asks a different question, very targeted question, that's about the spatial strategy. And what my learned friend Mr. Elvin is attempting to do is he's attempting to make the spatial strategy, which, as my lords have seen, is quite clearly defined on the pages that we've looked at. He's attempting to make the spatial strategy into the waste plan as a whole. He's attempting to bring into the spatial strategy the whole policy exercise that one goes through working through the waste plan as a whole, including such as policy WP21. And on WP21, just a small rider on that, of course, one only gets into very special circumstances if one is not proposing inappropriate development in the river. And there are various infilling and other policies on previous developed land, and some of that may have fallen on some of the allocations, but we're not going to get into that. My fundamental point is, let us not confuse the spatial strategy with the whole waste plan. My learned friend, both of them, are very keen to do so, because that then creates the exercise that suits them in bringing my lords to look at, under the question posed by policy WP4C, which is about the spatial strategy, and in particular the 3 points it references, the waste hierarchy, self-sufficiency and proximity principle. They want my lords to take into that and incorporate in that the sweep of the plan policies. That's the wrong approach. It's a quite narrow. It's a targeted criteria that we put P4. So how does it support the spatial strategy? If the plan had wished to say, let us imagine that the plan had said, not does it support the spatial strategy in particular, but had said, does it support or adhere to the following principles? Then the way would be open for my learned friends to say, well, it is the right approach to look at what is happening now. It's the right approach to look at the fact that waste ends up in Bridgewater and bringing it here to Portland, even though it's far from where the waste arises in Bournemouth and Christchurch and Poole, is better in terms of the proximity principle. It doesn't do that. It says, look at the spatial strategy. So we look at the spatial strategy, and that's very clear about where it is directing the waste.
So really the assumption in that exercise is something will come forward on one of the allocated sites. Even though the plan says in 1 or 2 paragraphs, it may not.
Of course, yes, that is the assumption, and it's a fair assumption.
That's a necessary assumption to the argument.
Yes, but that, my lord, is clear. It's clearly the basis upon which this plan is written. This plan is not written. In fact, Mr. Potter's proof, which some of the passages from Miss Hart's proof we went to, which refers to what Mr. Potter is explaining by reference to the inspector's report, so well, it has some of that. This plan is not written on any kind of assumption that the allocations will not come forward to meet the identified need. It it's written on the assumption that the allocations will come forward. And that's
But it
why
recognises they may not.
it recognises they may not. Absolutely. It recognises that they may not. But what it's asking under W4C is for whatever the proposal is, it wants it put in perhaps slightly bold terms. It wants it to do something like what the spatial strategy is doing with its 4 allocations, but on a non-allocated site. So you might not have these precise allocation sites come forward, but support the spatial strategy, please, in particular doing these 3 things. And of course, I don't, for a moment, I try to make absolutely clear, I'm not ignoring, we've never ignored the fact that policy WP4C has the 3 things that are in particular singled out as supporting the spatial strategy that one must meet. My point is that if you don't adhere to the proximity principle, that's still a fail. You can adhere to you can do the first 2, but if you fail on the proximity principle, it's a fail against the policy. So one must take.
Do you accept that when the proximity principle, sorry to interrupt, but do you accept that when the proximity principle is applied, it's not applied in isolation? If you apply it taking into account the other policy objectives like improving recycling rates and moving waste up the waste hierarchy, I can see there are problems if you just look at it in isolation and don't look at the overall picture. I hate to use the word holistic, but you know what I mean.
I know exactly what my lord means. Well, one looks at nothing in isolation in planning terms, provided that they're material
Well,
planning
not even the
considerations.
proximity.
But here is the thing. My lords are quite right to say the proximity principle is defined, and my own friend's colleague is wrong to say it's not defined. Nothing to the point that it's in supporting text. As my Lord Holgate said, it's absolutely commonplace, and it is defined. And I was coming to this at SB 24 at 316 in the first sentence, and it's quite bold. It just says, and this is correct, waste should be recovered or disposed of as close as possible where it's produced. Now, the way that, in my submission, the way that the other considerations.
Sorry, what are you deriving something from that? Are you saying that it doesn't really matter whether it's recovery or disposal because it put in the alternative? Surely it doesn't mean that, does it?
Sorry. Policy 4C. Policy 4C is applying yes, the proximity principle, but also the other 2 limbs. Meeting the needs and moving the waste up the waste hierarchy. So when one comes to ask the question at the end of working through 4C, does it adhere to the proximity principle? One doesn't need, in my submission, to be worrying about at that point whether or not my proposal doesn't adhere to the proximity principle because it doesn't move waste up the hierarchy, because we've already done that. That's the previous item, the previous criteria under 4C, and the same is true of contributing to meeting the needs. And as regards the broader points, perhaps, my lord. Well, what about if one has a site that's perfect for the proximity principle, but, and this is the example that is coming up here, what about if it's in the green belt, or what about if it's in a designated landscape area, and so on? Well, the answer is 4D.
What about if it's in the wrong position in the waste hierarchy?
Well, it doesn't get past
Yes, but
4C
this
waste
is what I
hierarchy.
find difficult, looking at these issues in isolation, ticking the waste hierarchy box without looking at the proximity.
No.
Either way, which
Well, one can't do that.
you shouldn't do that. You shouldn't take one before the other and say, well, that's okay now. That's predetermined how I'll look at the other issue.
No, of course one should not.
They should be looked at together, shouldn't they?
What together, sequentially, whatever way one does it, but make sure that they are all
They bear
looked
upon
at.
each other.
Yeah, and however one does it to make sure they're all looked at. But what one cannot do in my submission is one cannot take a proposal that fails the proximity principle in the context of the spatial strategy. We've got to read these words together. Adhering to sports delivery of spatial strategy, in particular, adhering to the proximity principle. So one looks at the spatial strategy, one asks oneself, what's that about? And then one looks at the proximity principle. One cannot find that a proposal that fails against the proximity principle by reference to the spatial strategy is compliant with 4C. Now, this is, we're delving into the policy detail and minutiae here in circumstances where the inspector has not, he has not looked at, when he goes through those paragraphs in section 12 from 12.100 onwards, he's not looked at, does this proposal support the spatial strategy? He's looked at the 4A issue. He hasn't looked at the C, spatial strategy, and all the issues in that. And I've already made my submissions to my lords about why one can see he's not done that, because he's so clear in his his inset references. The point my learned friend Mr. Elvin made about other references in paragraph 12.14, I just pick that up because that's a I mean in effect in defence of the inspector perhaps, but that's a misunderstanding of what the inspector's saying there. Let's see CB479. The point, and if my lords could have SB40 open at the same time, which has.
Sorry, can you give me the paragraph again?
Yes, so CB479, paragraph 12.14.
Thank you.
And SB40, which has policy 4 in it. What the inspector is saying, the reason he has made these side references here, 12.14, not what my learned friend Mr. Elvin was submitting. The inspector's point is, when he says, obviously, if there's a failure to accord with either, then bear in mind how policy 4 works. The comparison with the allocated site becomes academic. The either here being, of course, heritage and landscape. The point he's making is it's about 4D. And because you've got to comply as a non-allocated site proposal with the relevant policies of this plan, and which is how you get the other policies coming in. The reason he's got these items in the bracket there, in the square bracket, is because those are the parties' submissions on the waste issue, which he doesn't need to consider because of how policy 4 works, if the objectors win on heritage or landscape. It's a slightly roundabout way of doing it, but those references are to the totality, they're to all the waste, specifically waste policy submissions, which he actually doesn't need to get to if there's a failure against 4D. That's just to pick that point up. Now, my learned friend Mr. Coley appeared to raise, he certainly did raise, the conditional seeding point, and my lords discussed that with him, and he didn't appear to abandon it, although he didn't perhaps press it, but he did not appear to abandon it, as I understand it. There was no conditional seeding. There simply wasn't. Certainly not by my client, and it's certainly not a point that appears in the judgment below. It's certainly a point that my learned friend would need to put a respondent's notice in for, and he hasn't done so. So I say it should end there. But if my lords would like me to address my lords on it, then I will do so.
Do you think
Thank you very much. The other point that came up repeatedly in my friend's submissions concerns the statement of common ground. If we go to it, please, once more, and it starts at 224. I make the point once more. It is between the appellant and Dorset Council. That is, in many respects, the most important point about it, not with my client. However, when we look at the nub of the table of disputes at pages 253 and 254, we see policy WP4A dealt with separately from policy WP4C, and what we do not see, in my submission, we do not see an encapsulation of C that simply depends on the comparative exercise with Camford and Parley and Camford that the inspector does. And I say that reading the wording, in particular of the top box on the right-hand side fairly, the Dorset Council itself were not saying WP4C turns on a comparison between simply Parley and Camford on a wide-ranging basis. They are referring to where it is the spatial strategy puts the allocations principally around South East Dorset and near to the Camford MPT, and they are about the spatial strategy and the proximity principle. So I do say my learned friends are wrong to say that Dorset itself put the issue in a way that makes sense of the way the inspector dealt with it, and he was there dealing with WP4C because he was not. Similar, allied point, my learned friend Mr. Coley says, well, the parties didn't break their submissions down by reference to the different parts of WP4. Well, submissions are one thing. The inspector's been very clear, he takes the case as a whole. The evidence absolutely did deal with the different limbs in quite discreet way. I took my lords, but I'm sufficiently concerned that I'm going to do so again for good measure. I took my lords first to Miss Hart's proof, and I showed my lords how absolutely she breaks things down, and that was supplementary bundle page 217. Could we have a look at that, please? Because here and then over the page, to the top of page 219, we have a long discussion of the proximity principle.
Sorry, page
217, my lord.
Yeah, got it. Thank you.
Proximity principle, we have this long discussion of it. And
Yes.
what jumps out is that having done all of that, she rounds up with, of course, as such, the proposal cannot be considered to be in accordance with the spatial strategy and the relevant parts of policy 1, 4 and 6. And it's very clear that she then, from paragraph 850, she then moves on to consider WP4 criteria A. She parcels things up, as does Miss Tooley. And that, please, if we look to page 190, the supplementary bundle, if we start perhaps at page 187, in fact, here, my lords will see Miss Tooley's heading, where she deals with conflict with policy 4. Now, Miss Tooley absolutely takes it criteria by criteria. She is entirely clear, and she, having worked through A and then B, she gets to C at page 190. It's a false point in my submission from my learned friend Mr. Coley to say, well, the submissions didn't divvy things up, because the evidence certainly did, and it was quite clear and precise about that. We had from my learned friend Coley, Mr. Coley, made points again, and he persuaded the judge below of this argument that the spatial strategy is not primarily locational. Our point was and remains, and we can take it straight back to policy WP4C. The point about the spatial strategy, read along with that policy, is it's a sine qua non that you've got to get the location right. Yes, the spatial strategy is absolutely about ensuring you meet the need and doing so in accordance with the waste hierarchy. But it's the backstop. It's the primary thing the spatial strategy is doing is making sure that you meet it in the right places. You go up the waste hierarchy in the right locations, and that is what is at the heart of a spatial strategy. And this is indeed a spatial strategy. A side point really presented itself regarding what has happened with the allocations. Now, it's a side point, my lords, because the inspector doesn't reason. As I said, he doesn't reason on the basis that the proposals comply with the spatial strategy because the allocations have not come forward. Nonetheless, both of my learned friends made various points about the allocations not having come forward. They are tangential at best, points of detail regarding them, and my learned friend Mr. Elvin very fairly took us to the right part of Mr. Roberts' proof. Yes, a version of the allocations have been present in the waste plan since earlier, not identical, as Mr. Roberts fairly accepted. If anything, though, what mattered is that since the adoption of the waste plan, there had been very notable activity. The Parley allocation had actually been granted planning permission before this decision, and the Camden allocation was the subject of an application. That was then, so far as material, and of course my learned friend Mr. Elvin wants the court to know that ultimately the county allocation refused permission. But what matters is what was before the decision maker. What was before the decision maker, the Secretary of State here, was an officer report that recommended a grant of permission for Camden at the time the decision was taken. So those points about the allocations not having come forward, I say they're red herrings on two bases. One, the inspector's not reasoning that the spatial strategy is supported by this proposal because the allocations haven't come forward. Two, there was a lot of progress on the allocations since the adoption of this plan in 2019. I'm not taking these points in a very sensible order. I appreciate, my lords, and I apologise for that.
Doesn't matter.
My learned friend, Mr. Coley, said, as I recorded it, and I believe Mr. Elvin essentially supported this, that it's better in terms of the proximity principle to have a facility inside the waste plan area than outside. Now, if I've misrecorded that, I apologise. Of course, that's incorrect. We've got a big waste plan area here. Taking the Wildwood example, if one had a facility that was just to the east.
Well, he's not saying
No,
that, is
not saying that. Fine. But no.
I think we might have asked a question if he had it on.
Yes, very good. My lord has the point. My lord friend Mr. Coley went on to make a point based on, as I understood it, the St Moylan decision, paragraph 6.5 and 6, which in 6.5 in terms relies on South Somerset. The point being made, South Somerset, as my lords know, is a case all about whether or not policies were correctly interpreted. That's what that part of Lord Justice Lindblom's summary in St Moylan is covering off at paragraph 6.5. If policies are correctly understood, that is one thing. It doesn't mean that the issues are correctly understood or the evidence correctly understood and approached. That's a completely different thing. The inspector here, my only friend, relies on the words to a large extent, of course, in that paragraph 12.5. I rely on those words too. That's the inspector, for whatever reason, missing our issue. We had further reliance from getting into the meat of the decision, Mr. Coley, on paragraph 12.95. He said that is the reasoning of the proximity principle. Showed, my lords, why it's not. It's the reasoning on the greenhouse gas issue. It's got the internal references to the greenhouse gas issue, not to any of the WP4C issues. I think that my own friend Mr. Coley also made a submission that I struggled to follow. That, as I understood him, he was saying that the proposal would support the spatial. That the inspector found the proposal would support the spatial strategy better than allocated sites, as it's not in the greenbelt. Now, I couldn't follow where my own friend was referring to. That's not something that appears anywhere in the inspector's reasoning. If that is the inspector's reasoning, it, plainly for reasons I've explained, it's not a proper application of policy WP4C, but as I say, I cannot see those words in the inspector's report or anything approaching in the inspector's report. There's discussion under the WP4A exercise of can predict within that parking, but I don't know where those words, those finding words were said to derive from. I've looked. I believe Mr. Coley was in the crucial section 12.100 to the end, but they certainly do not present themselves to me. What we have, of course, is 12.108. Where the inspector says, as my lords know, Canford might well perform better in terms of the spatial strategy and refers to these locational benefits. But it's not remotely the finding that my friend Mr. Coley was aiming at.
Yes, of course.
Thank you very much, my lords. Unless there are any questions from my lords, those are my suggestions and replies.
Thank you very much indeed. Thank you all for your respective submissions. We are going to reserve our judgments. They will be provided to you in draft for the usual limited purposes. It's important that those limited purposes are adhered to, because if they're not, it is potentially a contempt of court. And we would anticipate that once you've received the draft, you will be able to agree an order, but if not, we'll deal with any outstanding issues on paper. So thank you again.
Court rise if able.